The matter before the court now is Carol Cutting versus Downey's Orthopedic Associates. This is docket number Penobscot 23410. I see counsel are present. I'm assuming ready to proceed. If counsel who would be arguing would identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Laura White for appellant Carol Cutting.
And Christopher Taintor for the appellee Downey's Orthopedic Associates.
Thank you. And we are being streamed live on the web, both by audio and by video. Attorney White, if you are ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. Good morning, and may it please the court. Although this appeal involves a lot of complex issues and many different issues for your review, this court can easily dispense with this appeal based on de novo review of the trial court's grant of a Rule 50 motion involving punitive damages. Criminal conduct, as alleged in this case, if true, is sufficient to justify an award of punitive damages, full stop. If the Maine legislature didn't find that a doctor falsifying a medical record, as alleged in this case, were reprehensible and outrageous, it would not criminalize it. The trial court agreed that the conduct alleged against Dr. McGuire was in fact outrageous. However, the court viewed the sequence of events as essentially an after-the-fact self-protective measure, if true, that we allege Dr. McGuire engaged in because he failed to obtain informed consent, and then covered it up by doctoring up a medical record, which is a crime. It was not for the trial court to decide what Dr. McGuire's motives were. That was for the jury to decide. And there are two important points that I'd like to make about the punitive damages claim. First, the Downey's argument about vicarious liability, which was never raised below, never briefed below, never discussed with the trial judge below, and it's been abandoned on this appeal under this court's precedent in Jones versus Secretary of State, 2020 Maine 113, in which this court held that if a cross appeal is abandoned, that an alternate basis for finding or for granting the Rule 50 motion cannot be brought. So we have a waiver of the issue below, and more importantly, there's no citation in defendant's brief whatsoever about vicarious liability not being available in a case where we allege not only negligence in the lack of informed consent, but then followed by an intentional reprehensible act. The other issue is harmless error. I understand it's easy to conclude that, well, the jury didn't find for you anyway, so they weren't going to find punitive damages. But we all know that, especially in a case as close as 6-2, we had two jurors on our side, that it can persuade a jury. Maybe one of those jurors concluded that they didn't feel the need to compensate Ms. Cutting because her arm was healed. They knew she was a recipient of Social Security disability benefits. Maybe they concluded she had Medicare and she didn't need to be compensated, but they wanted to punish and deter Dr. McGuire's reprehensible conduct. It was stated in opening, and then they heard in closings from Down East, that's not an issue in this case. You can't, this is just about compensating her. You can't punish the conduct of Down East. If just one juror were persuaded by that, and that means that they decided, well,
I'm going to stop you there for a moment. I see that the green light is on. So in this case, this was an informed consent medical malpractice case. I mean, I know there were other pieces to it, but at its heart, right, this was a lack of informed consent.
Correct.
Or the allegation was a lack of informed consent to the surgical procedure that was done, right?
Correct.
And then when you're referencing the criminal conduct, you're talking about the allegation that Ms. Cutting made that Dr. McGuire, in this case, had essentially falsified the operative note afterwards, right?
Correct.
Or at some point. But you opened up your statement by saying, I mean, when it went to trial, the jury found in favor of the defendant, the doctors, right?
Correct.
So you opened up your argument by saying criminal conduct is enough to justify punitive damages, full stop. Are you suggesting that punitive damages are in fact awardable for egregious conduct even if there is no underlying tort?
No, that's not what I'm suggesting. I'm suggesting that it's very possible it prejudiced the jury to such a point that it was harmful error.
Your argument about harmless error as well, they could have thought that maybe she didn't need to be compensated. But isn't that the problem here, is that regardless of whether there was sufficient evidence to generate a punitive damage instruction or to allow it to go to the jury, that having found that there was no medical malpractice to begin with, the jury can't award punitive damages?
I think that I agree with that premise, but the point that we're trying to make is harmless error is not our burden to prove that it wasn't harmless, that there was no prejudice. It is Downey's burden to prove that there's a substantial certainty that this could not have influenced the jury at all, the mere fact that the punitive damages claim was thrown out.
But the jury didn't find any negligence on the informed consent claim.
Our point is that the jury may have rendered a different verdict and reached a different result if instructed. Plaintiff's counsel told you in her opening that punitive damages were at issue if proven by clear and convincing evidence. The fact that they are then told by defense counsel in closing, no, that's not an issue in this case, makes it look like I'm telling them something that legally we believe should have been allowed for them to decide.
Isn't that a danger of overstating your case, though, in the opening? I mean, lawyers, you've done trial work before, and if you say, we're going to show A, B, C, and D, and during the course of the trial, C doesn't come in, the jury goes, whoa, so you misled us.
I think that's the crux of the issue, though, because we believe it was an error of law to not allow punitive damages to go forward. If that had not happened, then that statement made in opening would have been entirely consistent with the jury instructions.
But if it was error not to allow punitive damages to come in, you would prevail on that on the appeal, and the point you're making about the opening statement becomes moot. Doesn't it just engulf it?
I think had defense counsel not in closing reiterated to the jury, they mentioned that in opening, but that's not at issue in this case.
But isn't that the defense counsel's job to say, you're not looking at this thing? Maybe you thought it was part of the case, but it's not part of the case. What's wrong with that?
Sure. I think there's nothing wrong with that if the decision in the Rule 50 realm were correct as a matter of law, but it was not.
Can I ask you about some of your other issues here?
Sure.
You're aggrieved by the screening panel process. I mean, you're very dissatisfied with that. And as we know, with the screening panel, there's a group of 3 people who kind of hear the evidence, but it's kind of a lot of stuff comes in or doesn't come in at that point, and they can come up with a result that the jury hears about that makes a difference to the jury. But we have said in the past that, the screening process is constitutional, it is okay, and you'd have to overcome that precedent that exists out there. Why should we make a sea change in the previous decisions by the court?
So the screening panel process was, in my experience, extremely bizarre in this case, whether starting that off just because there was a snowstorm. But the fact, and I think common sense needs to dictate here, the common sense understanding that the screening panel would absolutely never say to a medical provider, we don't need a hearing, we've already found against you. The trial judge...
Let me interrupt you. You've got 4 minutes left. I want to make sure you take... Are you asking us to throw out the screening panel process or say to the Superior Court, take a look at what happened there, and if you don't like what happened, then don't give the instruction? Which of those are you
Correct.
urging?
So in the panel phase, my argument to the chair was, if you want to render a decision because you've consulted with the panelists and you all agree that there's a decision you can render, we can't tell the jury there's been a hearing. That's factually incorrect. You've decided the case on briefs.
There was a hearing.
There was, but essentially there was a back and forth with the panel chair where she said, I've talked to the other panelists, which frankly disturbs me in and of itself, to go to panelists and say, we don't need a hearing here, do we? But essentially that's what happened. She said, do you want to move forward with a hearing? And I said, if we don't have the typical Irish instruction that lets a jury know that a hearing was held, all of the instructions, defense counsel's response was, nope, they will get the Irish instruction, it will be the way it is, and that's just fundamentally flawed.
Okay, but under Rule 80MB4, if you want relief for cause based on the conduct or inaction of the chair, you have to promptly state the objection by letter to the CJ, the Superior Court, and get a ruling. Did that happen here based on what you thought was inappropriate conduct by the chair?
It did not, Your Honor, because my view...
Isn't that your remedy?
I don't think it is under a state of Nickerson, because I think it's very clear that when Rule 80M is not followed, those panel findings are inadmissible.
But in a state of Nickerson, what happened was that there was evidence after the fact that essentially that they had considered in rendering the decision after the hearing some additional information outside of the record. Here, what you're saying is, it seems to me that when you said you didn't really need a hearing, you've prejudged the case. Now, I will say as a judge, the fact that I might indicate I might not need a hearing doesn't tell you which way or if I have prejudged the case. But putting that aside, if you thought that was misconduct, indicating bias or the prejudgment, consultation with the others, I mean, Rule 80M provides the avenue for how to address that, and that didn't happen here.
My read of that rule is that typically that's for a process when something happens early on, which it did in this case as well, when the panel chair made an offhand comment about the nature of the claim in this case, and you're aggrieved by that and you have the ability to raise it with the Chief Justice. In this case, it essentially, the process was completed, and I was being told, we've decided the case.
Well, no, the process wasn't completed. They were telling you that before you actually had the hearing.
Correct, only because I said we still want a hearing, but I think it was...
Which you have the right to do and had.
Correct. I think the issue, though, is the panel findings are just a piece of evidence. It's just an evidentiary matter, and Rule 80M, the state of Nickerson, is clear. If you decide, if those panel findings are based on something other than what happened at hearing, they should not be admitted, and it's unconstitutional. This panel absolutely, I would say more egregiously than in Nickerson, decided without any hearing at all.
But that's really your assumption, isn't it? I mean, I guess to say that, well, they said, well, it got canceled because of snowstorm. We could, instead of rescheduling this, we can hear it on the record, i.e. the depositions and the other exhibits, panel submissions. You're assuming that's a prejudgment, but there's not actually evidence that we can look at that says it was.
There's not evidence that says which way they decided,
Well,
but
there
there
is evidence
is
saying it's a prejudgment.
I don't know if it's in the record. It was in the trial court. May I finish? Or,
Yes, you may.
In the trial court, there were emails exchanged and motions in limine where the panel chair did say, I have confirmed with the other panelists we have enough information to decide this case without a hearing.
Right. We have enough information to decide it, but it doesn't say which way. Am I correct?
Yes, you are correct.
Thank you.
Thank you.
Mr. Taintor.
Good morning.
Good
May it
morning.
please the court. I want to address the issue of punitive damages first. As I argued in our brief, first of all, I want it to be very clear, and I think it is clear from the brief, that we categorically deny the accusation that Dr. McGuire falsified the medical record. Even if that were true, however, even if, and the jury obviously found that he did not, but even if Dr. McGuire had done that, the trial judge made a completely reasonable and thoughtful decision that the falsification of the medical record did not contribute to any harm to Ms. Cutting because, as Justice Stanfield noted, this was an informed consent case. If there was harm, the harm occurred the moment the surgery occurred, not later in that day or the next day or whenever it was that Dr. McGuire wrote a note in which he
But
wrote that
doesn't
he...
his actions, I understand that that's what it was really primarily based on, but doesn't that also inform, let's assume, I understand you deny it, but, and the jury didn't find liability, but assume he had falsified the record afterwards. Doesn't that also inform the plaintiff's claim that essentially she was treated in a callous and frankly discriminatory manner, and that there was actually outrageous behavior that was so outrageous that malice could be implied?
Well, I think there again probably was sufficient evidence. I mean, clearly there was a factual dispute about this. There was enough evidence for a jury to conclude, based on Ms. Cutting's testimony, that Dr. McGuire had falsified the record. The question was whether or not that outrageous conduct, if it had been established, contributed to the commission of a tort or was related to the commission of a tort. And I think that goes to this whole question, frankly, the very opening statement by Attorney White, that outrageous conduct gives rise to punitive damages, full stop. That's simply not true.
So it's you're going with the language, I think it comes from Tuttle, that it must be the tortious conduct itself that is so outrageous that malice toward the person injured as a result of that conduct can be implied.
Absolutely. I mean, there are all kinds of things that people do every day. We're coming off an election cycle where people did outrageous things all the time and said outrageous things. That doesn't make them tortious because there's no actionable conduct toward a particular individual. And so, and again, if we talk about this whole concept of, or the allegation that Dr. McGuire treated Ms. Cutting in a discriminatory or dismissive way, again, that in and of itself is not a tort.
Can we talk a bit about the screening panel
Sure.
process? To what degree can a med mal plaintiff attack the goings-on of the screening panel during the course of the actual jury trial that occurs after the fact? Is there any door that allows them to say, well, you did hear about this thing that happened there, but is that permissive? Is there any avenue to do that?
Are you asking about in argument to a jury?
During the course of a trial, maybe trying to bring evidence in as to what happened at the panel?
I think you clearly can't do that. That's clear under a state of Nickerson.
Okay, how about during argument to the jury?
I think we're limited to the Irish instruction. I think
Is there a
this court has
due
said that.
process problem here? Because the screening panel process, as you know, is a unique animal that was created. Things go on there, it's very informal, the panel chair is given a fair amount of discretion, and it's quite possible that something weird, untoward may have happened there. But you're telling me a plaintiff is stuck with that they can never really get redress for any process that went sideways during the panel when it comes to the actual trial itself.
Well, I mean, I understand the argument. I guess I would say a couple of things. One is this court has said on multiple occasions now, I think, that the panel process withstands a due process challenge.
Right.
Here, there hasn't really been a frontal due process attack on the system as a whole. If there had been, plaintiff's counsel, appellant's counsel would have had to involve the state, and the state would have had to be here to defend the system. In fact, we had that issue with some post-trial motions that the appellant filed, where there were challenges to the confidentiality of the panel process.
But in this case, it wasn't really a full frontal attack, as you said, on the constitutionality so much of the statute that establishes the process, but she did attack how it happened in this case. I mean, in other words, that it was an unfair process in this case.
Right.
Whether or not it might be unfair in other cases. Did she do that in the right way? In other words, she moved in limine to keep out the panel findings because it was the result of a very unfair process and therefore should not be accorded any weight in front of the jury.
I hope that what you're saying is you're characterizing her argument as opposed to your conclusion.
Well,
Time will tell.
Time will tell on that, Mr. Taintor. As you know very well, I did many of these proceedings back in my day.
Right. I mean, I don't take issue with the way the appellant raised the issue in the Superior Court. I think the Superior Court reached the right result by concluding that it was impermissible to analyze what had gone on at the panel stage. I mean, even in the state of Nickerson,
But then what is the remedy? Let's assume you're right, and you're not going to raise it in front of the jury or as part of the instruction, et cetera. But if you raise it as a motion in limine, in other words, that the panel result shouldn't go in front of the jury, that it should just be set aside for purposes of this trial, because the process in this case was so fundamentally unfair. I mean, are plaintiffs, or for that matter, if it should happen to a defendant, although I think that would be extraordinarily unusual, hands completely tied in raising that fairness of the process when it was, let's say, really was fundamentally unfair?
Well, you know, there may be, it's hard to think of a situation in which it would be possible to challenge what went on sort of behind the curtain, if you will. I will say that there have been cases where defendants, respondents, feel that they've been treated very unfairly because, for example, you know, you're allotted a certain amount of time during the day to have a panel hearing, and the claimant takes up the entire day with their case, and the respondent never has a chance to put on evidence. And I will also say that, you know, Attorney White's assertion in a brief that these cases never result in panel findings for claimants is just simply wrong.
I'm aware of that.
Yeah, it's unsubstantiated. So,
how often would a panel tell the parties that they've been able to reach, they can make a decision against the physician based upon the record? Realistically, how often would that happen?
well, I don't think, first of all, I don't think I've ever heard of a situation where a panel said, without having had a hearing, we've made a decision based on the papers. And I don't think that's what happened here. They said, as I think Justice Stanfield pointed out earlier, or maybe it was Justice Connors, they said they had enough information to make a decision. They didn't say, we have enough information and we've made a decision. They said basically, look, we have all of these deposition transcripts, we have
medical records, arguments of
medical
counsel
records.
in writing, et cetera.
But the reason these panels exist is so that the healthcare providers and the lawyer and the former judge can sit together and deliberate on the cases. I don't think any lawyer or former judge makes a decision about a medical issue without talking to the physician who's on the panel. So just because they had enough information doesn't mean that there wasn't going to be some collaboration among the three panel members to reach a decision about what the result should be. I mean, it's completely unfounded, in my view, to suggest that there was a decision here made before the panel hearing that the claimant had no case. The panel was doing everybody a favor, frankly, by saying, look, we've had this, we've had this snowstorm, we can't hold the panel hearing. You have a couple of options. We can have a hearing sometime in the future, and as we know, claimants are often upset about the delay that occurs during these panel proceedings. So one option is we can have a panel hearing someday, or we can make a decision now based on the papers. Attorney White said, I'm okay with deciding it on the paper as long as the Irish instruction omits the reference to a hearing. Attorney Lavoie, who was lead counsel at trial, said, no, we should have the appropriate Irish instruction, and if that means having a hearing, we'll have a hearing. So they did. But it seems completely unrealistic to suggest that these three panel members who take oaths to follow the law made a decision without carrying out their duty under the law.
On the punitive damages issue, the trial justice found that the alleged conduct, if it occurred, indeed would be outrageous.
Right.
How does that how does that relate to the decision to exclude the evidence if it met the outrageous threshold?
Well, he didn't exclude the evidence. The evidence was in all throughout the trial. He concluded that.
Right. I meant
Yeah.
preclude an award of punitive damages.
Right. I think his analysis was exactly right. His words were the damage had already been done, and that goes to my point that in an informed consent case, if there's damage, it occurs when the patient undergoes surgery, not later on. So let me just give an example. When I'm driving up here today, if I had been in a car accident because I'd been texting while I was driving, and I got stopped by the side of the road, and while we're waiting for the police to come, and I throw my phone in a ditch. Throwing my phone in a ditch is outrageous conduct. It might even be criminal conduct, but it doesn't contribute to the commission of the tort. The tort is my inattention to driving and causing an accident. It's really the same thing here. We're talking about an allegation that there was a fabrication or misrepresentation or
You're saying
alteration.
that the
of
injury
evidence.
has to occur as a result of the outrageous conduct.
Exactly. I think that's clear.
Okay. Can I move to another argument that you
Sure.
made? And that is that in this case, the defendant is actually the corporate
Right.
defendant. It's not the individual physician. And you've argued that the corporation, in any event, would not be vicariously liable for punitive damages without at least some showing that they acted improperly as well. Is
Right.
that correct? Plaintiff has argued that because you have not cross-appealed, that avenue, that argument is not open to you. Do you want to address that?
Well, and we actually did cross appeal in this case on
I
a
know.
different issue, and then when I took over the case, it became obvious that the cross appeal was unnecessary.
You had a whole lot of issues, everything from res judicata to statute of limitations, et cetera.
But when you win, you don't need to cross appeal, and on this particular issue, I don't think there was any reason for there to be a cross appeal. I don't see that the
You're
argument
just suggesting
was
that it's alternate grounds for the Rule
alternate-
50,
certainly alternate grounds. Yeah,
and you don't think you need to cross-appeal on that?
no. I think that's what this court has said, and it
You're
was
not trying to affect the underlying judgment, and therefore you didn't need to have a cross appeal.
correct. Correct. I guess I also want to, and I think this was something that was alluded to in the questioning of Attorney White, mention the fact that, if she really thought that there had been prejudgment in the case, it was incumbent on her to raise the issue before the panel hearing. You can't sort of just roll the dice and hope that the result is going to be in your favor when you've already concluded that the case has been decided against you. And that's what happened here. According to appellant's counsel, they thought that there had been a case decided against them without the presentation of any evidence. That would be inappropriate. It would be the appropriate remedy at that point would be to raise the issue. In this case, and I hadn't even been familiar with the rule until the court cited it, Rule 80MB4, I think you said. The way to address that would have been to raise it with the Chief Justice of the Superior Court, not wait, go through the panel process, and then raise the issue on appeal. So I think that issue, frankly, was waived by not raising it at the appropriate time. Again, I think it's clear, the law has always been clear that there can be no punitive damage award without an underlying compensatory damage award. I see my time is up, Your Honor.
Thank you.
Thank you.
And Attorney White, you reserve 3 minutes for rebuttal.
Thank you, Your Honor.
Can I follow up on that last point? I mean, you did make the argument that because the issue of vicarious liability wasn't raised or briefed below, but also because there was no cross appeal, it's not open. Obviously, if it wasn't raised or briefed below, that may imply a different standard of review. But since they're not trying to change the judgment, but simply arguing an alternate basis upon which taking the punitive damages away from the jury could be sustained, aren't they entitled to do that?
My reading of Jones is that it's not necessarily just trying to change the judgment, it's raising an alternate legal basis for.
Well, we say that all the time, that we can affirm on a different basis, for example, the different reasoning than the judge gave.
True. I think the issue, though, is not only was this never raised below, as Attorney Taintor was arguing, I recalled that we actually had evidence of Dr. McGuire being in a physical altercation with a patient before this happened with my client. The police
What does
came.
that have to do with anything?
What it has to do with it is if this had been argued in the trial court on the Rule 50 motion, the vicarious liability issue, we would have argued to the judge, oh, they were on notice that this doctor had some problems. The practice was on notice just based on these events, and that was a whole bunch of evidentiary stuff that we weren't able to get in, some we were. But the point remains that the vicarious liability issue should have been discussed and briefed in the trial court so that we could have raised those arguments to prove that, in fact, the practice, I don't know of a single main case saying that vicarious liability works differently in the punitive damages context.
You filed your brief. You said, this is why I win. He filed the red brief that says, here's why the decision was right, and added an alternate ground. You didn't file a reply to respond to that alternate ground. Why didn't you?
The reply would have simply said they waived this by not raising it below, and it's clear that they can't do that. They can't raise, sure, the court can find on an alternate basis, but they never argued, and the trial judge never decided anything related to vicarious liability. So without that being, and really their focus was on the clear and convincing evidence standard, and actual malice not being present. Those were the two bases argued for throwing out punitive damages. If they had said, also, by the way, we think that vicarious liability can't lie here, we would have had responses to that. So I think they've completely waived that issue. It's a non-issue in this appeal, not having raised it below. I just wanted to address as well this issue of almost sequentially what happened to Ms. Cutting. And it's ironic because this has already been to this court once before on raised judicata arguments. This is a whole common nucleus of operative facts. They've already argued that everything that happened is all related. His discriminatory bias toward her, the surgery proceeding without consent, and then the falsification of the medical record after. Thank you.
And thank you, counsel, for your argument in this case. As you may have noticed, you have a bit of an audience here today. We have a class from the high school. And if you wouldn't mind, we are going to take a recess briefly, if you would, and then after a few minutes, we're going to come back and meet with the high school class, at least to talk to them. But while we're out, if you wouldn't mind remaining perhaps and taking any questions, I think that would be very appreciated. I don't know if there are any questions, but you might be able to answer some questions that we actually can't. Or are not permitted to. Not that we don't know the answers, but we're not permitted to tell you the answers. So that would be lovely if you could do that. But we'll take about a 5 or so minute recess, a 10-minute recess before we come back in. And as is our usual practice, again, we're not going to issue our decision here today, but we'll take the matter under advisement and issue a written decision in due course. With that, we'll be in recess, and as I say, we will informally come back and meet with the class in a little bit.